everybody. Welcome back to Module 2 of Law, Politics, and Society. I hope you had a great week and were able to stay warm, particularly over the last few days. In this module, we're going to be going further and talking about how legal frameworks affect our conceptions of justice and how justice evolves out of law. So to understand whether or not law creates this entity known as justice, we would have to be able to define what justice is. And this is something that theologians and philosophers have pondered for millennia. And justice frequently means different things to different people. For some people, it's an ideal and not a tangible thing. For other people, it's synonymous with fairness or equality. But there are different theoretical definitions from previous theorists that are informative in how our legal system approaches justice. Originally, Aristotle looked at justice as consisting of treating equals equally and unequals unequally according to relevant differences. And we're going to talk of that when we move to a slide in a couple minutes on distributive justice, because Aristotle was a true believer and really the origin of the conception of distributive justice. Whereas one of the very famous Roman jurists of about the same era as Aristotle, Demetius Ulpianus, defined justice as a constant and a perpetual will to allot every man his due. The idea that we would have those scales of justice, the lady of justice, holding up her balanced scales, making sure that we treat other people appropriately according to their sins, or now according to their crimes. And you can think of this as more of an eye for an eye or a tooth for a tooth model of justice. And we often call it retributive justice. And we'll talk about that more in a couple minutes. So Aristotle came up with this view of distributive justice. And one of the important things to understand about it is it really relates to how political entities, such as nation states, distribute resources to its members or its citizens or its legislative bodies. And if there are no good reasons to distribute resources unequally, there's no relevant differences between society members, then there should be equal resource distribution. But if there are relevant differences, then there need to be rightful, merited, and deserved distribution. It wasn't about who necessarily needed items, but on their value to the community, on their level of contribution, and what their allocation would do for society more broadly. And so this is much more about merit, much more about contribution than it is about need. So if we apply this concept to school and students, how would an A student feel about giving D and F quality work A grades because the student who submitted the D and F quality work needed A grades to get into law school? Probably not very well. This wouldn't sit very well. They wouldn't feel very well about this because although that student may need the grade more, they didn't earn it. They didn't achieve it. And this is one of the things that Aristotle and Aristotelian philosophers put value on, the idea of output and what you have done to deserve your results. And so while compassion can be an element of justice, it is not necessarily the abiding or overruling one. And Marxists aren't a big fan of this. The very famous Marxist quote is from each according to his ability to each according to his need. Would not have sat well with Aristotle. He was not a fan of wealth distribution or rewarding people for inferior outputs. He would not like the participation trophies or giving people ribbons just for turning up. He had very strong beliefs that we needed to reward excellence, and when something wasn't up to par or something wasn't a sustainable output, it wouldn't get rewarded. The same way we reward elite athletes, and quite handsomely with, sometimes over reward them perhaps with salaries in leagues like the NBA or the NFL. But, NCAA athletes don't get paid. Is that just because they're not as good? Do they not deserve it? It can be a complicated phenomenon. Retributive justice, on the other hand, is much more interested in procedure. And we're going to talk about procedural and substantive law a little bit later, but I just want to give you sort of a brief overview. So procedural law is the way in which we put limits on state actors and say to, for example, police officers, you can't infringe on other people's rights and liberties in your pursuit of justice. You need to get a warrant. You need to give Miranda warnings. You need to abide by these very strict set of rules that have been laid down. Whereas substantive law puts limits not on state agents, but as all members of society. Substantive law is the criminal code, the official rules set down that says we can't jaywalk, we can't kill, we can't rob, we can't steal, and that applies equally to all members of the community. So substantive law is concerned with all individuals' actions, whereas procedural law is concerned on how we enforce and the procedures in which we enforce substantive law. So retributive justice is concerned with the procedures, concerned with the substantive pieces to a degree, but most interestingly concerned with how we determine guilt and innocence and how we determine appropriate or proper punishment. And under a retributive justice philosophy, society must punish using fairness and impartiality if it's going to achieve justice. One of the quotes from the text is, equals must be punished equally and unequals punished equally according to relevant differences. So if two people steal and they steal the same number of things with the same monetary value, they need to get the same sentence. Whereas if somebody steals a loaf of bread, but another person murders somebody, those need to be very different punishments as set apart from each other to make sure that different messages are being sent and there's different levels or hierarchies of punishment. One of the issues that often comes up in retributive justice is the equality of pain versus the equality of the instrument that is providing the pain. So when we look at the equality of pain, often we're looking at sentence length, how severe the punishment is, or how big the fine is, versus whether or not the instrument, either the judge's opinion or the lawyer's recommendations, are equal. And one of the issues that comes up in society is sentencing disparity, that one judge thinks one sentence is appropriate for an armed robbery and another judge thinks something different, and another state deals with armed robbery entirely differently. And one of the ways that we've tried to minimize this in retributive justice is in some ways to operationalize Aristotle's definitions of distributive justice in sentencing guidelines. So this is to ensure just punishment, take into account relevant differences, take into account the characteristics of the crime, how grave the crime was in terms of the statute, how much value was lost to the victim, and whether or not there were any mitigating factors. Was the person doing this in self-defense? Were they doing it out of necessity? But also characteristics of the criminal themselves. So not the offense, but the actual individual. Do they have a prior criminal record? Do they have a mental illness? How old are they? If they're 8 years old, there might be a very different level of responsibility. Are they the family breadwinner? All of these things can matter if we're going to punish like with like, different with different. Some scholars have argued that there might be problems, however, with Aristotle's "we must treat equals like equals and differences with differences," because how do we determine what equality is and what differences are relevant? Is it just conduct? Is it socially ascribed statuses like social class or race or gender? What mitigating factors matter? Which ones don't? How do we decide? All of these things are going to be important when we have two individuals in front of us who maybe committed the same crime, but perhaps for very different reasons. The process is also almost never going to be identical, largely because of the current economic system. Some individuals may be able to afford a $500 an hour attorney, where other individuals are relying on public defenders or have chosen to represent themselves. Justice can be seen as a commodity that's for sale. You can buy your way out of justice. The phrase, the best justice money can buy, is used for this reason. An example of this, if some of you have watched the show The Jinx by an HBO crew from a few years ago, it's about Robert Durst, who was accused of committing a number of murders, who got bail because he was able to afford $250,000 in cash. So he just walked up and said, all right, $250,000 for bail? Great, buy jail, and walked out. Right? How realistic is that for most people? It's not. And so it shows you the disparities of our justice system and the way that economics can play into that. And often that's not seen as a relevant difference, perhaps as much as it should be under Aristotle's definition. And understanding there are problems with the way that the law is applied brings us to legal realism. So this is not a study of philosophy or a theoretical study of law, but it's a study of actual legal decision making and how the law is applied and what the implications are of that application. So we evaluate law as it's being practiced right now. And legal realists look at the way administrators deal with the legal system, the lawyers do, the judges do, and how juries respond as well. One of the things that influences this is, and the reason why legal realism has become so popular, is that it's often non-legal reasons that explain judicial decisions. We'd like to think that lawyers restrict themselves completely to the law and no other factor but applying the law, and judges and juries the same. But we know that judges and juries are susceptible to the same biases as every human is. They may like a defendant more than another one. They may believe a defendant more than the other one based on implicit biases like sharing their religion or their ethnic background or their gender or their political ideology. We know that these things affect even the most learned judges. We have studies of the Supreme Court, and we can break down decisions based on political ideology and other legal philosophies. And so we know that law is often more indeterminate than we wish it was. The legal rules matter, they influence, but they don't always determine the judgment. And oftentimes there are other factors that get in the way. Your text provides 4 really good examples of times that have been particularly appropriate to use legal realism. The first, in chronological order, was Lochner v. New York, second, Mueller v. Oregon, third, Bush v. Gore, and most recently, the nomination hearings of Sonia Sotomayor. But we can also see some of the legal realism at play during the most recent hearings for Brett Kavanaugh as well. And oftentimes we see the highly politicized nature of these disputes as tarnishing the rule of law. Chief Justice Roberts came out during that process and said that he was very concerned that the Supreme Court was getting more and more politicized by day, and that perhaps the wounds of the Kavanaugh hearing would never actually heal on the Supreme Court. We know that the Supreme Court is a political entity. We know that those individuals have biases and they tend to side with the party that appointed them. But it's difficult to reconcile that with such an openly partisan and very difficult confirmation hearing like the one that Brett Kavanaugh went through. The claim that the United States is a country of law, not men, is unfortunately not as true, perhaps, as we would like it to be. Frequently, emotions get in the way, biases get in the way, our perceptions and opinions of right and wrong get in the way. And often those aren't based entirely on the facts. And so I encourage you to read through these 3 cases and think about how legal realism applies in these cases and what other principles might have been guiding the decision apart from law. Last week you read about the natural law perspective and you watched the crash course video on natural law. But I want now to show you the 2 ways in which natural law have competing perspectives in some ways. So we have the transcendental natural law perspective and the evolutionary natural law perspective. So we're going to start with the transcendental natural law perspective, which believes that there are laws that have existed since the dawn of time. They transcend all societies and cultures. They are universal and timeless. And that when natural law conflicts with man-made law, natural law is the one that should be followed. The ought of law runs downward from some transcendental realm. And the idea of this is that through education, through legal study and training, scholarship, the what ought we to do can be discerned. The natural law is a philosophy of law. It's not a formal set of statutes or procedures, but it believes that there is this law within a law, that there is God-given understanding and knowledge that can be achieved. And this is what Dworkin really believed in, that you could come to one right answer for every question if you used this moral, natural, divine understanding of law. It very much agrees with Plato's concepts of forms. It is much higher than statutes and procedures. It literally means a more compelling or higher law in Latin, juscuns, which is this international legal community term to mean above, a higher law. So it's considered a law within a law largely, because it is often contained within holy books, and it has been used to bolster government, the idea of a monarchy and the divine right of kings, that somewhere in the heavens it was laid down that these are the individuals who were ordained to rule, has set out precedents for divine monarchies. But it's also been used to refute governments in the way that we see in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed with certain inalienable rights. These are natural legal frameworks invalidating constituted English colonial laws. It makes plain that they were not granting rights to the people, but ensuring that rights were protected. They're not always religious. You can have secular humanists or people who believe that there are powers beyond that which we can know that have been set down that don't necessarily have to have a belief in God, but that understand that there is some sort of higher power, a higher order perhaps, that is at the root of all legal understanding. On the other hand of the natural law perspective, we have the evolutionary perspective, which is the scientific equivalent largely of the transcendental perspective. It looks to explain the origins of law and society wholly in reference to the principles of evolutionary biology. And so according to evolutionary legal theorists, law flows naturally from the evolved nature of Homo sapiens more generally, and humans have continued to learn and grow and adapt to their understanding of law. So in that way, law is natural in that it's evolved over time. And evolutionary legal theorists always seek empirical support for their views through the study of human behavior and previous human cultures. They found that law frequently arose in most cultures, almost at every juncture, and found that the desire for fairness and to use morality was a universal trait. The evolutionary perspective really begins and ends with the idea of choice. And they believe that humans are biologically predisposed to make certain choices, usually based on constructs of their own morality. And these choices are far too important to the well-being of society, but also to the well-being of individuals, to be hardened by positive law. We can't give away the moral outrage or our understanding of choice to just written down codified systems. We have to keep our moral understanding of right and wrong intertwined with law. And according to evolutionary perspectivists, the most important choices eventually generate belief systems that perhaps they originated in some transcendental realm. But most evolutionary legal theorists are concerned with what is now, rather than what ought to be, what should be. In that way, they're much more focused on the current legal system and how we got here, rather than what could be in the future. In the evolutionary perspective, then, morality evolved as a challenge to behaviors that were inherently exploitive, as a consequence for things like thievery. And moral outrage is often a basis for revenge, because revenge is what makes credible threats against amoral or inappropriate behavior. This moral outrage needs to be buttressed by retaliatory action, and the plausible candidate is the basis for the sense of justice. Right? How do we get back to a sense of equilibrium when there's been this exploitive behavior? How can we bring that back into balance? And so laws are learned, but are motivated by this innate need for justice, for bringing things back into balance, for ensuring that there is sort of this harmony and good, and that anything that strays from that is eradicated. And one of the things that we have to make sure we avoid is something called the naturalistic fallacy. And that assumes that what is and what ought to be are the exact same thing. And it's not true. What is something that can be observed and understood and measured through science and math and empirical equations. What ought to be is really a moral hope that is dependent on society having the same moral views and structures as the one who is hoping. And so evolutionary theorists do not synonymize something that is natural for something that is good or desirable. Just because something is in its state doesn't mean that that's what it should be or could be. And we have to make sure that we're not putting moral and relative judgments to things that are. And this is why we avoid using things like good or desirable to avoid couching things in normative terms. So one of the ways we can start to conceive of the relationship between law and justice is in the English courts, particularly the equity courts. So equity is actually Latin for just, and it refers to the remedies of wrongs that were previously not recognized in the English common law system. So the common law of England was originally overly rigid. It was incredibly concerned with the things that were prescribed and set down. It was very technical and was quite clearly not just, arguably not just. And so this removed any sort of ideas that law and justice were necessarily synonymous. And this is why equity courts were created. It was to temper common law courts, to give them some flexibility, to allow justices to fashion new remedies that maybe didn't appear in previous statutes because there was never this situation. Equity courts then, as they evolved, fed into common law courts. They adapted the jurisprudence from the equity courts and allowed more flexibility, realistic understanding, and knowledge. So it created a better English common legal system. And any distinction between the common legal court and the equity court was eliminated, in 1875. So this allowed the equity court eventually to be replaced by the common law of England and created a much more just, fair, and equitable legal system. One of the ways in which legal theorists tried to put natural law into action was Raphael Garofalo's attempt to make a natural definition of crime. So Garofalo disagreed with the positivistic definition of crime. That is, crime is whatever the law says it is. This idea that as long as it was written down by the right people and put into the magic book of all the things that says that crimes are these things, then it's a crime. And he said that crime should be universal and that law should be universal. And so he created two categories of crimes: mala in se crimes and mala prohibita crimes. Mala in se crimes were natural crimes. They were crimes that have always been against nature. Things like murder, adultery, theft. Whereas mala prohibita crimes were man-made crimes. Things like gambling or drug usage or sex work. They were crimes that the state said were crimes, but not necessarily universally condemned and not really understood in any sort of meaningful way across time. And so he believed that mala in se crimes were the crimes that were universal, that they were the just crimes or the correct crimes, whereas mala prohibita crimes were man-made and therefore less relevant or had less authority, certainly. And we can see this oftentimes in the levels of punishment. Mala in se crimes are almost always punished much more severely. They're almost always felonies, whereas mala prohibita crimes, not so much. Mala prohibita crimes also tend to change more frequently, like the legalization of marijuana in some states, the decriminalization of sex work in Nevada. These aren't universal crimes and they're subject to change, which makes their enforcement really difficult. So one of the things that's really interesting about law and justice is that our conceptions of both of these things have continued to evolve. And this has been true throughout legal history, and one of the best examples of this is the author Cesar Beccaria. Now, he's often seen as one of the founders of criminology, as he wrote a book called On Crime and Punishment. And he was writing really around the time of the French Revolution. It was a time that there was a lot of social upheaval, and it was during this experiment with democracy and anarchy and chaos that he said law needs to be rationalized, it needs to be humanized, it needs to be brought back to earth, and we need to be more reasonable in our punishments, more rational in the way we hand them out, and we need to make sure that we do this in a way that everybody understands. So he didn't question the need for punishment, and he didn't think we should get rid of it entirely, but he thought that they needed to be more rational and more proportional. He also thought that laws should be designed not to be retributive, to take revenge, or to somehow satisfy our bloodlust, but only to preserve public safety and societal order. And this really revolutionized our thinking about law and justice. All of a sudden, we weren't supposed to be tarring and feathering people and shaming people as a goal to avenge a crime. But now the goal was flipped to be about protecting social order and public safety. Beccaria took issues with the king's letters, which was essentially a mechanism where the king could be displeased with any individual and accuse them of a crime, sending them a letter stating that they had been accused of these crimes, and then subsequently punished. He said that society would lose respect for a system of law when it didn't have any rights to defend itself against potential tyranny. And Beccaria argued for many of the rights we have today, including the right to a fair and speedy trial, the right to a trial by jury, the right to protect ourselves from self-incrimination, and the right to counsel. So a lot of the modern conceptions of law and justice that we have, particularly in the Bill of Rights, came from Beccaria. So one of the people that often doesn't get enough credit for their role in helping to evolve criminal justice specifically was Sir Edmund Coke. And he was a major figure in the evolution of British common law about 100 years before Beccaria was writing. And Sir Edmund Coke was imprisoned by King James I of England because he told the king in letters and subsequently to his face that he did not believe the king was above the law and that Parliament was never intended to be subservient to any monarch, including the current one. So not entirely surprisingly, he was convicted of treason. But after his release, he was elected to Parliament. And he ended up drafting what has been called now the Petition of Right, which argued for protection of all habeas corpus provisions, as well as a trial by jury, and that the trial by jury would be done by the individual's own peers. So something that we would be quite familiar with today. Initially, Charles I, who succeeded James II, was also not a very big fan of of Sir Edmund Coke's. Charles I was not very happy with the Petition of Right. He didn't think that he needed to adopt it. But eventually, Charles acknowledged these petitions as being correct after a fairly significant amount of parliamentary and citizenry pressure. And Sir Edmund Coke, for this, is often called the father of due process. We're going to talk about what that means in a minute. And he was also the first person to suggest written procedures for implementing substantive criminal law. That is, that the government would have very specific rules as to what they would be allowed to do in enforcing their substantive criminal law. All right, so one of my favorite people to talk about when we talk about law, crime, and justice, and politics and legal theory is Herbert Packer. And so Herbert Packer was writing during the Civil Rights Movement in the 1960s, and he was talking about the way that law and justice interface. And he said that there are two competing value systems and choices that will underpin all criminal justice systems. One embodies traditional conservative values, and one involves and embodies traditional liberal values. And these are called the crime control model and the due process model. One of the important things to note about these models is that they should be understood as a spectrum, with crime control on one hand and due process on the other hand, and a whole lot of space in between. Not as a dichotomy where you just put crime control, a slash, and then the due process model, because it is a spectrum and all societies will fall somewhere on that spectrum between an absolute crime control model and an absolute due process model. And so I'm going to ask you in discussion where you think the United States fits on a crime control due process spectrum, so you can start to think about that. The crime control model emphasizes, above all else, protection from criminals. It wants the community to ensure that it is safe. And to that end, civil liberties only have real meaning in a safe, well-ordered society. And so then it is necessary to swiftly suppress criminal activity and do so in a way that is final with as much efficiency as possible. So we want a swift, efficient, final criminal justice system that takes care of any deviance. Cases should be handled informally and uniformly in an assembly line type fashion where you can go yes, no, yes, no, yes, no for criminals, minimal appeals because you need the finality of the process, and minimal rights for the accused. You want to make sure that we're dealing more with their guilt or their innocence rather than technicalities or procedural issues. The due process model, in a lot of ways, is the opposite from the crime control model, because due process itself is defined as the system of procedures in place that holds the government to its principles. Due process are things that we don't earn, we receive in society as a way to make sure the government holds itself accountable to its own understandings of justice. And so in that way, the due process model is an obstacle course where the crime control model was an assembly line. The due process model wants to avoid efficiency and speedy processing because it wants to get it right. It wants to avoid any impingements on civil liberties. We might have to suppress evidence if the police did something to get it in a way that was illegal. We might have to put police through their paces and make them obtain warrants and not interrogate suspects without legal counsel. The due process model is much more concerned with the integrity of the legal process. Did we do things properly? And are you legally guilty? Encompassing the whole system, then are you factually guilty? Did you actually do the crime? And so most people, when we talk about the criminal justice and due process model, fall somewhere in between. There are very few people that are pure due process model believers or pure crime control believers, but generally people will fall somewhere in the middle. There are three cases that your text uses to demonstrate the models of criminal justice in action. The crime control model run amok in Brown v. Mississippi in 1936. That one is certainly true. This involved the murder of a white man, allegedly, by three black men. And instead of having a trial, the three men were sentenced to death under convictions that were obtained purely from their confession, which was received by torturing these three black men. And they were told that the torturing would not stop until they confessed. So completely unreliable confessions, no independent evidence that these three men were in any way responsible for this person's death. And so you can see the danger in the crime control model. But the due process model has its own dangers if we believe that procedurally the procedure is more important than the substantive law. And so in Brewer v. Williams, we have an individual case where a person knows the location of someone who has died, ostensibly because he was the one who killed her. But that confession can't be used because the police obtain it with a violation of the right to counsel. They didn't inform him of his right to counsel, and they assumed that he had waived it, and he maintained that he didn't. So that was an opportunity for somebody who likely murdered another individual who might have gotten away with it, but for the golden mean between the two models, according to your text. And this is Nix v. Williams, so this is the appeal to Brewer v. Williams. And in Nix, we see the confessions and the violation of the right to counsel affirmed, saying yes, there was a violation, and yes, we recognize this. But there was what was called inevitable discovery. That is, the police would have found the body, and so independent of the statements that were inadmissible, that alone would have been enough to convict. And so recognizing the procedure, recognizing the substantive, and getting the right result. So I know that this has been a lot of theory and it's been really heavy for the first 2 weeks, but good news, we're going to be getting away from the theory into more fun things next week. But what I want you to think about when you think about the crime control due process model is the statement that really sort of hits home for people in the crime control due process model is it's better for one guilty man to go free than 10 innocent men be incarcerated or punished unreasonably or incorrectly. And how we feel about that statement often reflects how we view the crime control and due process models. And this means a lot going forward in terms of how we view each of the individual amendments to the Constitution and how they've been interpreted. So we're going to move on to Chapter 3 next week, and I'm looking forward to seeing you all then. Cheers.